thank you everyone for coming to the webinar today. I have some hot topics that you may have seen in the news lately. So I just a quick poll: how do you track HR compliance news in the newspaper, the internet, through My HR Council, through our newsletter or blog, or some other method of tracking HR compliance news? So it looks like the majority of people track HR compliance news through internet sources, and about a third of you use My HR Council's newsletter, which is great. We always keep that up to date. That's something that our attorneys are working on day by day, trying to keep you up to the minute. Sometimes it's hard to stay up to date on the internet. You don't know when an article was published, if something has happened within the past few days, that's thrown everything up in the air. Keeping up through My HR Council is a really great way to keep up. So today's agenda, we're talking about the salary increase for exempt workers, the ban on non-compete agreements, the Pregnant Workers Fairness Act interpretive guidance, how these changes came about, and then the current states of litigation with all of these laws. So the ban on non-competes. The Federal Trade Commission, unless if you're not familiar, is 5 members appointed by the President and confirmed by the Senate, and no more than 3 members may be of the same political. They have issued a final rule. When they issue a final rule, it has to be published in the Federal Register, which is our U.S. code, our federal laws. So when it's published in the Federal Register, that makes it a federal law, and it becomes part of the code that we all have to abide by. Now, some states have already banned non-competes, and it will stay that way regardless of what happens to the federal ban on non-competes, regardless of whether it gets enjoined. The most employee-friendly law always takes precedence. So if something happens to the federal non-compete rule, and you have a more employee-friendly state law that has a ban on non-competes or a restriction on non-competes, that's always going to take precedence over that. So a quick question: do you use non-compete agreements? Yes or no? So it looks like a majority, about 2/3 of you, do use non-compete agreements, which is an amount that I would have expected in the industry. The new ban, the gist of it is that all new non-compete agreements with workers and senior executives will be banned. This includes non-compete agreements with employees, independent contractors, interns, externs, and volunteers. So no more drafting non-competes, no more having workers or independent contractors, anyone sign them. The FTC has really broadly defined non-compete as any contractual provision or workplace policy that has the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. So employers are going to have to provide in writing all former and current workers who have an existing non-compete clause, who are currently bound by a non-compete, with clear and conspicuous notice that by the effective date of the ban, the non-compete clause will not be and cannot legally be enforced by the against the worker. Um, so you will have to inform all employees who are bound by a non-compete that the non-compete is no longer effective, except for senior executives. Senior executives, existing non-competes can stay with the senior executives, but you can't sign any new ones. They're the employees other than senior executives past restrictive covenants don't have to be voided. Senior executives, the old ones, can stick around, but no new ones. And so you can prepare for the rule to going into effect by compiling lists of names who have non-competes and draft a letter, but do not notify anyone until 120 days after it is published in the Federal Register and not enjoined. So you don't have to worry about it quite yet. And you do have to take care that your non-compete provisions are tailored as narrowly as possible. And that agreements containing confidentiality clauses and other language to protect against a worker taking company trade secrets and other propriety information to a competitor. So the FTC does not impact measures that businesses can take to lawfully protect their confidential and sensitive information, but non-solicitation agreements have to be very carefully drafted by an attorney to fit in compliance with the ban. So nearly 1 in 5 people are covered by a non-compete. That's 30 million people. So non-competes decrease competitive conditions in the workplace. So think about it. You have less freedom to choose with a non-compete. If a company's non-compete knocks 300 people out of a job in your area with a layoff and says, well, you can't work for anyone who competes with us within 100 miles, are they going to relocate to abide by the terms? Well, your coffee shop just lost 300 customers, and will you stay open? Or will just the big name coffee shop across the street stay open? Suddenly people can only choose corporate coffee. And if you don't want your employee to go work for a competitor, you can always incentivize them with better working conditions or higher wages. The non-compete is not the only answer. So the salary threshold increase is not as controversial. It is in the news lately, but it's just kind of, it is what it is, and you have to grit your teeth and accept it. It's not it's just not facing a lot of objection. So every position must pass the salary test, the minimum salary threshold, and the duties test for employees to be exempt. Now, some states have higher salary thresholds than the federal government, which is fine, but you must pay at least the federal minimum salary threshold for employees to be exempt. So there's an increase in minimum salary coming on July 1st, 2024, and another on January 1st, 2025. The duties test is going to remain the same. Now, if you make a position non-exempt, you may not be able to get that exemption back from the DOL. So if you're admitting that it is a non-exempt position by nature, and the DOL is going to see it as a cash grab if you try to make the position exempt again at a later date. This is our current amount and what is coming in less than a year. You can see here on the little chart. So it is currently $684. It is going to $844 on July 1st of this year, and January 1st of next year, it will increase to $1,128. These are weekly salaries, so this is the requirement for paying your employees weekly. And generally, we say hours worked over 40 in a work week as far as calculating overtime. So this is the salary for the work week. Exempt employees that are becoming non-exempt are not going to understand how to clock in and clock out, the importance of recording all time, punching out if they go to a doctor's appointment, how to draw a broad line between compensable and non-compensable time. You will have to train, if you aren't going to pay the salary threshold and you're going to pay these employees hourly instead of salaried, you're going to have to let these newly non-exempt employees know that a phone call or an email after hours is hour work, and they have to put that on their time card. Now, if you have a newly non-exempt employee because you didn't want to pay the salary threshold and instead wanted to pay them hourly, and they keep getting overtime because they're used to working as much as they can to get the job done, you need to have a hard talk with that employee. They're used to managing their own time, but you need to manage their time now and let them not permitted unless directed by a manager, and they need to not work when not scheduled. So the Pregnant Workers Fairness Act, was passed by Congress last year. So this is a law that was voted on by Congress and signed by President Biden, and it became the law last year. Now, what's happened lately and why it's in the news is because the EEOC issued interpretive guidance saying this is how the act should be interpreted as far as what as far as discrimination, or like the ADA, how we guide the ADA according to the EEOC. They issued guidance for the Pregnant Workers Fairness Act. So according to the new interpretive guidance, the question on everyone's mind when they hear about the new interpretive guidance: do I have to give my employee the day off to get an abortion? Yes. You may have 1,000 hypotheticals, like what if we use attendance points and this would be her last point? No, and I can't make an answer to your hypothetical question that exists only in your imagination. I can only answer legal questions that are for things that are actually happening for particular employees who are actually doing something. Those are the only questions I can answer. I really can't answer a hypothetical question that hasn't occurred yet. But making making an exception to the attendance policy is a reasonable accommodation. If you live in a state with a total ban, doesn't matter. If the employee is going to travel across state lines to get one, you have to give them that day off. Can you ask for evidence? No. You can ask for proof of whether or not the employee was pregnant. Now, your group health plan doesn't need to cover this, but you have to give your employee the day off if she needs it for that reason. Do you have to buy your pregnant employee a standing desk because she has hemorrhoids? Yes. These are things that you have to do to accommodate pregnancy and accommodate all of the conditions that are associated with pregnancy. You have to accommodate everything from preconception all the way to post delivery. Everything in between is, this law doesn't just let you off with giving the employee a stool to sit on. Asking for accommodation is protected activity. If you fire an employee who asks you for a day off to get internal birth control placed, that employee can take you to the EEOC with a retaliation claim. And I will tell you, retaliation is the most common claim at the EEOC and the easiest to win. Do not terminate anyone who asks for a pregnancy accommodation. If the employee can still do their job or light duty, you cannot force them to take a leave. You do the interactive process just like with the ADA, but the gathering medical information part is limited to asking, are you pregnant? Predictable assessments, accommodations that are always reasonable, never require documentation, and are never considered an undue hardship for the employer. So these are always required. Letting an employee who usually stands sit down, letting an employee who usually sits stand up, more water breaks, more snack breaks, more bathroom breaks, having water at their workstation or nearby, and any lactation accommodations. Those require no documentation and are never an undue hardship. So you can never claim undue hardship with those accommodations. You cannot use your ADA interactive process form for this. You cannot require the employee's healthcare provider to fill out a form of any kind. The only documentation you can require is that the employee is pregnant and that the medical condition they need accommodations for is related to pregnancy. So its documentation is the bare minimum to establish if the employee is pregnant, if the condition she needs accommodation for is related to pregnancy, and some accommodations that might help. If it's episodic like migraines, all you get is a note that says migraines related to pregnancy, and you cannot ask for a doctor's note after each absence. Now, litigation in the news for the laws we just talked about. So as far as the non-compete ban, Ryan, a global tax service, has sued the FTC, arguing that the FTC does not have the authority to issue the rule. The rule is unconstitutional and the FTC is unconstitutionally structured. The U.S. Chamber of Commerce has filed suit in the Eastern District of Texas, and they have filed for a preliminary injunction. ATS Tree Services, which is a business with only 12 employees, has also sought injunctive relief in the Eastern District of Pennsylvania. So they feel that strongly about non-competes, even though they only have 12 employees. As far as the Pregnant Workers Fairness Act, 17 Republican states attorneys general have filed suit against the EEOC, claiming that because the PWFA guidance includes abortion, the entire statute is unconstitutional. Not a lot of favorable precedents in the Eighth Circuit. Do they have standing to get an entire law that was passed by Congress completely off the books and declared unconstitutional by suing the EEOC? It's kind of a very novel question. We'll have to see how that shakes out. And a federal district court has managed to block enforcement of the Pregnant Workers Fairness Act against the state of Texas, and that was really on unusual grounds that they were able to do that, so it is not enforced in the state of Texas. So it looks like we've met our time here. If you have any questions about, like I said, a specific information that is actually affecting a particular employee of yours, or how one of these laws like the non-compete ban is going to affect your particular business or your employees, please feel free to open up a ticket. We'd be happy to give you a legally backed answer from our licensed attorneys. If you are not a client, please go to info@myhrcounsel.com. Thank you all for participating today, and I hope you all have a great rest of your day.